Hello, landlords. It is Ernie Garcia, landlord attorney, and we are here on a Wednesday for the first time in a while. I know that the last couple of Wednesdays I've been out because of trial work. In both instances, we had trials go way long, and we're going to do whatever we can to win our cases for our clients. And so last week it was a jury trial. The week before that was a non-jury trial. But yeah, we sometimes go longer than we originally anticipate. And so we were out there fighting for our clients and winning cases. So I appreciate you being flexible. We did do other accommodations in both weeks where we held it on Friday instead. In fact, for those of you who are not aware of yet, next week I'm actually out on vacation and will be back. So in 3 weeks, so not next week or the following week, the next live we'll do will be 3 weeks from today. So I'm happy for those of you who are here. Brian V says, good afternoon, Mr. Garcia. Good afternoon, Brian. Good to see you. James is here again. Hello, James. Good to see you both. We're just going to go ahead and get started on today's topic, which has to do with how property management is different for remote landlords. And sometimes, remote landlords don't consider these differences and really know, what, to expect. When you're leasing property in the state of Texas, or if you're in Texas and you're leasing property in another state, or you're just in a different part of the state. We got people who live in Dallas but lease property in Houston, Harris County, or they live in the Valley and they're leasing property in San Antonio. You got to consider what is possible whenever you are a remote landlord. And so for those of you who are thinking about the possibility, could I do this remotely? You absolutely can. And if you find that there is an area of the state or an area of the country where you might have an interest in purchasing property and leasing property, understand that lots of landlords do this. If you are a landlord who manages property remotely, let me know in the comments. I'd like to hear precisely from you guys if you have that kind of property, because you can help others who are maybe a little timid and not ready to take that step. It is absolutely possible, and it's something you could do. I'm going to give you 5 tips, things to consider if you are considering being a remote landlord. We have Fan who says, good afternoon, Mr. Garcia. This is Terry. Hello, Terry. Lucy says, good afternoon. Lucy Balian. And then Brian V says, up in Lampus County, and my triplex is in Giddings, Texas, 2-hour drive. That's exactly what I'm talking about. You may not be right next door, but it doesn't mean you can't be an excellent landlord. Lucy says, I do manage my property remotely from another state. So there you go. Just right here this afternoon, we've got people who are already remote landlords. For those of you who are interested, here's what we have to say about it. Absolutely, if you are remote, you're going first. Just to start off, you're going to need somebody locally to sign your lease and deliver your keys. Now, it's true that you can sign things remotely. However, I'm going to caution you against complete remote first meetings with your tenant, because we know that this is where, and recently we did a video on tenant swapping. This is where tenant swapping occurs, or fraud tends to be flown under the radar. You're going to want somebody that you know, like, and trust, who can examine people right at the get-go, have that sit-down talk, do that eye contact thing, where the tenant understands the rules that you require for renting your property, but also so that you can confirm with a physical ID and a face-to-face conversation who is actually signing the lease and who will actually occupy the property. This is important. If you cannot do it, have someone in place who can. Now, sometimes landlords will come in specifically for handing over the keys, and I'll tell you, if you can be there, it is worth it to prevent a headache from a tenant swap. So if you didn't catch the Tenant Swap video, of course, it's in our catalog of videos. It came out just this week. I strongly encourage you to watch that. But as far as having someone local, it could be your realtor. Maybe you have a property manager, but if you're managing properties, you're going to want someone who you know, like, and trust in the local area who can at the very least hand over keys and confirm that the person who's signing is the person whose face is on that ID, who is the person you're going to be leasing your property to. Next, you probably need a digital way to collect your rent. You don't want to make it complicated for your tenants to have to wait for someone to come and collect it for you and then they get the money to you. You're probably going to want to establish a tenant portal. Maybe you have a designated bank account where tenants can go and deposit money. Some people use cash apps like Venmo or Zelle. They have their limitations, but if you have an ability to collect money remotely, that's going to make your life as a remote landlord so much easier. For those of you who do landlording remotely, how do you collect rent? Is this something that you already employ for your remote tenancies? Do you have a tenant portal? Do you have a bank account? Do you use cash apps? How do you do yours? I'd like to know. Next, you need someone on standby for all repairs, especially for emergencies. You absolutely need that no matter where you are. If you are local, you're going to want somebody on standby that you can collect. If it's not you, make sure you've got someone in the bag who you know can show up on a moment's notice. If you don't have that, you're already a few steps back. And so by having someone in place who can respond, especially in the event of an emergency, you're going to spare yourself those kinds of claims from tenants that you did not act with diligence. The court is not interested, by the way, in the fact that you are out of state or out of town or on vacation. Your proximity to the rental does not by itself give you additional time in terms of diligence. If there's an emergency item that needs to be dealt with within 24 to 48 hours and you can't get to it because you got to drive in and it's got to be only on the weekend, and so you're going to show up 6 or 7 days later, court is not interested in hearing any of that. That's not a viable excuse. Make sure you've got something in place, someone you can rely on who can show up on a moment's notice in response to an emergency. But also some of this to the day-to-day stuff. You know, if you've got someone, for example, who you are evicting and you simply need to confirm, have they moved out before I file this eviction? Why do I want to spend all this money if I can simply have someone drive by the property and confirm that the tenant is still living there? You need somebody local who can respond on a moment's notice, particularly to repairs and especially when it comes to emergency repairs. Here's a tip for you that's pretty easy and probably doesn't cost you a penny. Get to know your neighbors, especially if you've got neighbors who've lived in the neighborhood around your property for 1,000 years. Those are the best neighbors because you can call them to do a simple check. You can ask them, hey, is anyone snooping around my property? I picked up something on my rain cam. Neighbors can be invaluable pieces of information. They can be eyes and ears when you live 100 or 200 or 500 miles away. And so get to know your neighbors, and then, you know, drop them a Christmas basket or something from time to time to say that you are appreciative of, you know, the help they give you whenever it turns out that you give them a quick call and ask questions that they can, you know, answer for you much faster than maybe a maintenance person can do it, and maybe with more diligence than even a property manager can do it. You know, you give them a call, somebody you know and you like, someone who lives right next to your property, and they can confirm, nope, the lights haven't been on for days. Those people definitely moved out. I talked to them as they were moving out. I watched them load up the U-Haul, and they moved out 4 days ago. This kind of connection with your neighbors is extremely helpful, particularly when you are very far away from your rental property. Let's see, James E. chimes in and said, beware of the laws in the state you own property. That's absolute. So you live in Virginia, but you've got property in Texas. You don't go by Virginia law. Even if you had your tenants sign a lease that says Virginia law, a court may say, nope, we're scratching that out. And because they live in Texas, they're going to be subject to Texas law. So be aware of that. If you are in Texas and you own property in the state of Oklahoma, make sure you understand where the lines are drawn for your legal rights and your legal obligations. Very important. Particularly if you live in a state that does things drastically different. If you're in California, you're loving the laws in the state of Texas if you're a landlord, but vice versa, a headache. If you live in Texas and you lease property in California, it's a very pro-tenant state, and the fact that you're only familiar with Texas law is not a defense in the state of California. I can guarantee you that. Tiger Harris says, good info. You're welcome. Thank you very much. Alexander says, this is an excellent topic. I appreciate that. I'm hoping this is helpful to you guys. And James E says, yes, sir. Hey, guys, I appreciate you chiming in and adding your questions and comments. I'm going to get to pre-asked questions for those of you, and I've got one more point, but before I get to that, I'm going to get you these questions. I got quite a few. For those of you who are not members of Texas Landlords, if you have rental property in the state of Texas, on Facebook we have a group, Texas Landlords, and I imagine most of you are probably associated with that. You can ask your questions there every single week, except for the next couple of weeks while I'll be on vacation. But generally speaking, you ask your questions there. We post it, you ask your questions. I answer those questions here live. But if you don't get a chance to ask your questions on Texas Landlords, every single time you can chime in here and I'll answer those questions on the live. The final question has to do similarly to what we just commented on, being familiar with the laws in foreign states. If you've got property out there, you also have to be ready for lawsuits. And so if you are sued and you've got property in another state, guess what? You're going to have to show up there and defend it. If you live out of state and you've got property here, guess what? You're going to have to show up and defend it. Now, you may hire counsel or you may have a property manager who in the justice court can show up on your behalf. But if you're the named plaintiff in a case, especially on an appeal, and in certain civil claims, especially in the county court or the district court, you might have to show up yourself and you might have to testify. And the good thing is that modern courts sometimes have modern remedies for modern problems, one of which is that we do have a lot of remote owners who lease property in other states. In some instances, you can request the court to allow you to Zoom in and you can testify. In Harris County, for example, the majority of our eviction appeals are heard on Zoom. So we represent clients who live in other states. We represent clients who live in other countries, and we'll often send them a Zoom link, prep them for the trial setting, let them know the time in Houston time. And once we're ready to go, everybody goes live on the Zoom and we testify that way. But it's not always that simple. You might be in a smaller jurisdiction where the judge says, nope, you're going to be live in front of me, no questions about it. I don't do the Zoom thing. Well, and you're subject to the rules of that local jurisdiction, and so you have to be prepared for it. If you're going to file an eviction, be prepared at some point. You might have to show up. If you are being sued, guess what? You can be sued in the county where the property is located, and if you live outside of Texas, you can expect a lawsuit in the state of Texas, particularly in the county where the property is located. So a few things for you to consider. I hope this was really helpful for you. If there's anything I missed, don't hesitate to give me a question here in the chat. I'll be happy to answer those questions for you. For now, let's get into our previous questions handed to us through our Facebook group, Texas Landlords. Our first landlord is Lucy, who asks, what are your top 5 recommendations for remote landlords having a Section 8 rental tenant in San Antonio? Well, I just gave you the 5 that I would say have someone locally who can sign and, kind of view your incoming tenants. You need a digital way to collect rent. You need someone on standby for repairs. It helps to know your neighbors, and lawsuits are going to be if the property is in San Antonio in Bexar County. And for those of you who don't know, Bexar County, that's the county, B-E-X-A-R, Bexar County, believe it or not. yeah, you can expect litigation out there if you've got rent property. In terms of Section 8 and remote work, there really isn't a whole lot of difference, except that, you know, to get the thing going on Section 8, you're going to undergo some inspections and you're going to be subject to their regulations. And so just understand that at the beginning, it's a front-end loaded prospect. But if you've already got someone who's approved, your property's approved, and you're rocking and rolling, there really isn't a whole lot different with a Section 8 tenant, except that because you're receiving Section 8 funds, you are subject to a 30-day notice to vacate in the event of an eviction. You also typically have to send notice to the Section 8 liaison. So there's someone in the housing authority who is your contact person. If you're sending a notice of default, or notice to vacate, a notice of termination, or a notice of non-renewal, make sure you are also sending it to that liaison through the housing authority associated with the Section 8 funding. Sometimes landlords get themselves in trouble because they communicate exclusively with the tenant, which is typically what happens. But now that Section 8 is involved, you're going to want to communicate, also CC that liaison and make sure they also get all of the same notices in writing that you're sending to the tenant. That's it. I hope those 5 help you in terms of remote work, and then a couple of tips that kind of generally apply to Section 8. Anna April asks, how much does it cost to set up a series LLC, a lease agreement, and have the house transferred to my LLC by special warranty deed? I want a lawyer to do it. Thanks. Well, a series LLC is an excellent device that you can use to add a current property into an LLC and then ultimately other properties. Now, my expertise, this goes beyond it. So while I can set up a single member LLC, I don't set up series. That requires slightly different drafting that I would suggest you speak to a business law attorney or a business formation attorney about. They can help you with that. In terms of a lease, you can get a lease in a number of ways. We offer a lease. In fact, this summer, we're probably going to offer a lease at a promotional discount. I don't know if I'm saying that too early or not, but we plan to do that probably in the middle of the summer. Right now, we're charging a flat fee of $650 that comes with the lease, your addenda, and then ultimately a 30-minute session with one of our attorneys, and then even some redrafting and kind of reformatting that lease to suit your needs and any additional revisions you would like in that lease. Again, we're probably going to run a sale on that later this summer. I'll give you more details probably after I come back from vacation. But as for transferring to an LLC, that's also something we can do. But if you have a business formation attorney, it may be something they dabble in. I don't know if all business attorneys also know how to transfer properties. That's also something you can come to us for, and we can discuss that process should you need it once your series LLC has been set up. And so I hope that's helpful, Anna. Forrest J. Green asks, what happens if you are sued in small claims and you just don't pay your judgment? What happens if your tenant just doesn't pay theirs? I've heard you can't get them put on a credit report. How does it affect you? Well, yes, as of 2018, judgments are no longer featured on credit reports, but you can abstract a judgment at any time and create a judgment lien. Now, why is this important? Well, let's say that I've sued a tenant and I won a $5,000 judgment, and now I want to abstract that judgment to create a judgment lien. Well, what this does is it establishes for future lenders. Let's say someone's buying a house. That same tenant is later, 5, 6, 7 years down the line, buying a house, and they're going through title, and the lender comes across, or the title company through the lender's office comes across a judgment lien for $5,000 plus attorney fees and interest, and says, whoa, we are not loaning this money until this judgment lien is cleared. This judgment lien poses a potential threat to our collateral. So I'll get a call at that point. I'll be asked, what's it going to cost to remove this judgment lien? I'll call my client. We work out the details, bada bing, bada boom. I calculate the amount's paid, the lien is released. So an effective way for a landlord to record that judgment is through an abstract of judgment. So even though you can't get on a credit report, you can establish a judgment lien that future finance companies are going to see, and it will have a negative impact on the tenant until it is released. A judgment lasts for 10 years and can actually be renewed for another 10 years indefinitely if you really want to do that. As for a judgment against a landlord, well, here's the problem. If the tenant has a judgment against you and you've got a rent house, guess what? That rent house is potentially subject to seizure. And if the tenant sues you, abstracts that judgment, and then seeks what's called a writ of execution, and I've got videos on all of these things, abstract of judgment and writ of execution. They seek a writ of execution against you. You've got a big fat non-exempt piece of property in that rent house that will be seized by the constables and will be set for a constable sale if you don't pay out that judgment. So when it comes to tenants, it's somewhat difficult to collect, especially in the state of Texas, to collect against tenants. There's all sorts of tenant protections. But when it comes to landlords, you've got a lot to lose. And so a landlord can see their property seized in the event of a lawsuit. I would take care of those judgments and not just let them go by the wayside. I see James adds here, I'd be so nervous going to court. Don't be nervous. There's all sorts of resources here. I'm happy to help any way I can, and I'm sure we can figure something out. Lucy says, I use Property Manager to pick best Section 8 tenant with the highest rent I can charge and where tenant pays majority rent. Can a judge, and she goes on, can a judgment lien be created on prior evicted Section 8 tenants? How much does it cost to file a judgment lien? I use an attorney for the eviction. Well, as long as that attorney is still representing you, they can help you with that process. But if you've got old judgments, again, they're good for 10 years and can be revived, right, indefinitely. So let's say you got a couple of judgments from 2020, they're just lying around, and you now want to abstract them. To abstract a judgment, you basically need 3 identifiers. If you only have 2 or you only have 1, you can still use it, but once you got 3, you can really narrow down your defendant. So let's say your defendant is named, Mike Johnson. Well, I guarantee you there's a lot of Mike Johnsons out there. And so you're going to add to the abstract, when you request it from the court, the last 3 numbers of the social, the last 3 numbers of the driver's license, and their date of birth. There's only one Mike Johnson who's going to fit all 3 of those identifiers. And the more identifiers you have, the better. If all you have is the date of birth, or all you have is the social, the last 3 of the social, that's helpful. But you might find another Mike Johnson that shares, the same birthday or same last 3 of the social. I mean, that's mathematically possible. But the more identifiers you get, the less likely it is anybody else. You're likely going to narrow it down to the one individual. And then create this judgment lien against them. So yes, if you got old judgments, as long as they're not 10 years old or older, actually, even if they're older than 10, you can actually revive a judgment within a 2-year window, even after the 10 years have passed. So even a 12-year-old judgment can technically still be revived. We can talk about that if you need assistance with it. But yeah, if it's 3 or 4 years, abstract it, create that judgment lien. Who knows? Your tenant may ultimately seek to purchase property, and you might be able to collect on that judgment. Okay, question 4. Shushma Girish asks, how can I start the eviction process? Well, I'm going to give you a very basic rundown. I'm assuming you're talking about the state of Texas. But to start the eviction process, number 1, you have to determine what your basis is for the eviction. Usually it's non-payment of rent, but it could be some other substantial violation of your lease, even if rent has been paid. For example, someone might have an unauthorized occupant. They might be conducting illegal activity, or they might have done something to severely damage your property. All of those are probably listed in your lease as major defaults. And so, follow what your lease says with regard to written notice regarding anything that has to do with non-payment. But in any case, once you have established a default, particularly, again, the big one is non-payment, you send a notice to vacate. And in the state of Texas, the default amount of time is 3 days. We send our notices to vacate by regular and certified mail. Once the requisite amount of time has passed, we file in the justice court where the property is located. So you got to understand where your property is located in your given county and which justice court is applicable to it based on its location. We file in that court. You wait to the trial date. We present our case at trial, which is usually a copy of the lease, which proves the agreement, which is usually a copy of our rent ledger, which probably establishes non-payment, or other documentation that establishes any non-rent related violations. We produce a copy of our notice to vacate, which is required under state law. And then we talk about our damages, whether that's unpaid rent, whether that's possession only, whether that's attorney fees, court costs, interest, all of those things we present to the court and then seek a judgment. So that's how you start and prove up your eviction. Sushma, I hope that was helpful. And if you need any further advice or further assistance, there are tons of videos on that very topic on my channel. Check those out. Or you can give us a call. We'd be happy to talk to you about the eviction process. All right. Alexander Valentine asks 5 questions. Strap in. We're going for a ride. Here we go. First, he starts off with, good afternoon. Good afternoon, Alexander. Here we go. Thank you for taking the time to share your insight and expertise. Here are 5 key questions I'd love to gain more knowledge on regarding remote property management. 1, what legal risks and responsibilities should remote landlords be especially mindful of? Here's a big one. Because you are remote, you have a huge risk in between tenants. Sometimes property is left unattended and uninspected for too long. And so a couple of things could happen. Number one, if your property is unattended for more than 30 days, your insurance policy could lapse just based on the fact that you don't have a tenant in place. If you've got landlord-tenant insurance, but you don't have a tenant on the property, read your policy. It might lapse after 30 days of no occupancy. Why? Because the risk of vandalism, the risk of a break-in goes up precipitously. The other issue is the risk of vandalism and the risk of a break-in go up. And so you got to have eyes on your prize. You got to make sure that if you cannot physically care for or watch over your property, then you've got people in place who can. Maybe that's a handyman who routinely goes and just inspects, checks things out. Maybe it's your very good friend, that neighbor that we talked about earlier, who's checking things out for you. In any case, one of the biggest risks that remote landlords assume, and sometimes don't think about because they're not around to see it, is what happens to my property in between tenants. This is where you get in those squatters, because you're just not watching the ball. Somebody sneaks in, they assume residence, and guess what? Not only do you not get to put a new tenant in, now you got to take somebody out who's probably a professional tenant, knows exactly what they're doing. They spotted an abandoned house, they liked it, they came in, they established residency, and now you have to deal with them. So that's a pretty big risk. Question 2, how can remote landlords ensure their property manager is fulfilling their obligations and safeguarding the investment? Well, one way is to be clear as to, what it is their obligations are to you. Are they reporting rent? Are they giving you reports as to the contractors that they hire? Are they sharing information with you on a regular basis? Are they inspecting the property? Are they accepting late rent without issuing notices to the tenant? That's not good. You want to know that the way they're managing your property makes you money. If the way they're managing your property loses money, it's simple math. They're not a very good property manager. And so how do they deal with defaults? How do they deal with repairs? And how do they find new tenants for you? Those are the big three things that property managers really should do at Tip Top. If they take forever to replace tenants, if they're terrible at following up when repair requests are made, and if they're not doing enough to make sure that rent is paid on time, and if not, they're sending notices or issuing or instituting evictions, that's probably not the best property manager for you. Question 3, are there specific lease clauses or addendums that remote landlords should consider when managing from a distance? So the lease requirements probably aren't going to be any different. What might be different is the way you inspect your property. And it might be understood that while I own the property, I'm going to have another party conduct routine inspections. And I always recommend an inspection after 3 months and an inspection after 9 months. The 3 and the 9 are crucial. Make sure if you can't be there to conduct that inspection, that you've got someone in place and that the tenant is aware of this person who will come in after 3 months, after 9 months, or whatever regimen you've got set up. That's one thing that I would definitely mention in the lease or your house rules as to how things will be conducted a little differently, strictly because you are a remote landlord. Question 4, what's the best way for remote landlords to handle maintenance requests, inspections, and legal notices when they can't be physically present? Well, we talked about inspections, we talked about maintenance requests in the big talk at front. You definitely want somebody on standby who can address those requests, especially emergency ones. But in terms of legal notices, I still rely pretty heavily on the U.S. mail, regular and certified mail. I stand by it mostly because courts still love the U.S. mail. But I strongly recommend that your notice provision, but this is true of every landlord, have multiple means of contacting your tenant when it comes to notices, right? We know that the notice to vacate requires, very limited court accepted notices, regular and certified mail, top of the list. But that doesn't mean for notices of default, notices to terminate, notices of non-renewal, reminders, notices of non-payment, notices of small changes, little updates. All those can come through email, text, through your tenant portal. And so if you've got an email address, that's great. But imagine if you had 4 email addresses. You've got 2 adults, each with a personal and a business email address. Have them disclose it all so that you can notify them in so many ways. There's no way they could ever say you didn't reach them. So always the notice provision, don't let it slide, whether you're remote or not. But definitely if you are remote, make sure you've established not just one excellent method of communication, but multiple of them. Always as a standby, regular and certified mail, but for quick contact, have a tenant portal, have multiple emails, have texts, all sorts of things that are helpful and multiple. And number 5, what are some best practices for communication and documentation to help avoid disputes with tenants or property managers when managing remotely? So this is similar to what I mentioned with the multiple avenues of communication. One thing that I want to caution all landlords against is to have exclusive communication over the telephone. In fact, I would strongly recommend that you limit your telephone communication. And it's not going to help. Well, I record all of my calls. Maybe, but recorded calls, I can tell you from experience, are terrible evidence. Terrible, terrible evidence. It's hard to prove. It's hard to substantiate who's on the phone. Your best bet is to keep your communication in writing. Email, letters, faxes if you still do that kind of thing. Communication through the tenant portal is huge. But as long as you're communicating in writing, you are explaining explicitly what you mean, and by demanding responses in writing and not simply letting them pick up the phone and say, nope, I don't want to communicate through the phone. Communicate with me through email only or through text to a lesser degree. But that tenant portal for sure. Email is good. Sending, snail mail, also good. By insisting on keeping your communication in written format, you're going to save yourself a lot of headaches when a dispute arises, because nothing's worse than the tenant or your property manager saying, well, you told me X on the phone and I did X. It's going to be hard to disprove that, right? Whereas if it's in a written format, it's explicit, it's in black and white, easy to prove. Lastly, from Alexander, once again, a big thank you, Attorney Ernie Garcia, for taking the time to share your expertise. Alexander, you are extremely welcome. James, I'm missing a few things. Lucy writes, what's the difference of a notice to vacate and a notice to terminate the lease? That is an excellent question, and it's something that's commonly misunderstood, Lucy, because there's a huge difference. A notice of termination simply says, at some point in the future, the lease will come to an end. It does not require fault, and it's not usually based on fault. It is a non-fault document that says, at a certain point in the future, the lease will come to an end. This is also true of a notice of non-renewal. And so you might have an automatic renewal clause in your lease that you don't want to enforce, or you might be on a month-to-month tenancy and you simply want to say, look, we're just not going to renew it anymore. So as of this date, you can consider the lease terminated. The reason that's different than a notice to vacate is because a notice to vacate is a present demand for possession. And a notice to vacate only happens when something has gone wrong. The tenant is in default. You can prove that default. And because of that default, their rights to stay on the property are immediately terminated. The reason that sometimes people get it confused with a notice of termination is because of the fact of immediate termination. Well, you can't do an immediate notice of termination. You usually got to give at least 30 days, right? Sometimes longer, depending on your lease. But a notice to vacate could be as little, technically speaking, as 24 hours. I don't recommend the 24-hour notice to vacate. I always recommend a 3-day notice to vacate because some judges get queasy about 24 hours. But 3 days is the default, so go with that. Unless your lease requires longer. But remember, the notice to vacate is an immediate demand based on default. They didn't pay their rent. They broke, the kitchen door. They set fire to the living room. They have an illegal or unauthorized pet on the property, or they held over. You sent a notice of termination and they stayed. They didn't leave. Well, guess what? Now they are in default. And while the original notice of termination did not cite default, if you gave a line in the sand and said, you got to be out by this date, and they stayed beyond that, now they have violated the lease. Now you can send a notice to vacate, and now you can sue them for eviction if they don't leave. Whereas the notice to vacate alone, the notice of termination alone is simply a date in the future when the lease will come to an end. It does not imply default. That's why it's different. The notice to vacate says you have broken the lease. You are in default and you have to go now. If you don't leave within this time frame, then I will sue you. That's not present in a notice of termination. Okay. James says, what are you looking for in the inspections? So I talked about the 3 and the 9 inspections. I'm looking for basic things. You can look for specific things on your own, but here's what I recommend to landlords on the 3 and the 9. At 3 months, if that place is torn up, you're issuing notices of default, and you're probably gearing up to get that tenant out. But assuming everything's fine, you go on to the 9-month. And at the 9-month, again, if you see that the place is torn up, you're issuing defaults and probably gearing up to get rid of this tenant. But if the place looks good, If the place looks real good, you're thinking, what can I do to keep this tenant in place? That's what makes these inspections invaluable. You don't want to leave it up to them entirely whether they're going to decide to stay. You may like the way they treat your property. You may like the fact that they always pay your rent on time. And so you may begin as early as after 9 months, wooing them into a lease extension. So it helps to know precisely that this is the kind of tenant you want to keep and to know it early. That way, when the time comes, you're ready to offer them a lease extension and keep them there because you like the way they treat your property. Just the same, if you find out earlier rather than later in the process, this is a bad tenant, not somebody you want to keep, you want to institute your notices and your eviction process sooner rather than later. All right, so question number 6. We have G. Duran who asks, I'm not a realtor. Can I use the Texas Realtors residential lease form? Renewal is coming up, and I was using the contract from Zillow, but found it not very comprehensive. Any suggestions? Thank you. So here's the problem with the Texas Realtors lease. There is a clause in the Texas Realtors lease that says if you use this lease, it belongs to Texas Realtors, and they'll give you a license if you're a member. Non-members may not use the lease, and the lease is voidable. And so if your tenant finds out you use the lease without permission, guess what they can do? They can void the lease. So I never recommend using other people's intellectual property without their permission. Certainly, if you hire a realtor and through that hiring, you are given license to use their lease, by all means, use the lease. However, if you are not a member of the Texas Realtors Association, or you were not extended a license, I can't recommend that you use their lease. You subject yourself to potential voidability by a tenant. Joy Stanchik writes, can a landlord rescind a lease? Potential renter keeps pushing back the start date, and I am nervous. I drafted a lease, but can I just cancel it? What if renter signs anyway? Can I refuse to sign my part? I'm not real sure what the facts are in this case, Joy. It sounds like you offered a lease to somebody, but the tenant keeps saying, nah, I don't want to sign, nah, I don't want to sign, nah, I don't want to sign yet. If they sign, do you have to sign it back? So a couple of things. If they're still bargaining with you on a start date, you don't have a set agreement. So if the lease already had a start date and they've blown past it, guess what? They can't sign that lease without making a revision to the start date, possibly the end date, and getting you to agree to that change. So if those are the facts, then they probably can't sign it unilaterally. But if you're thinking, well, they're holding the lease, what if they keep that start date and just eat the lost days? They pay me the rent and say from this day forward, we'll pay everything from start to finish and we'll only lease until the end date. Again, if they've blown past that start date, they haven't paid your rent, they're technically in default the moment they start. Could they convince a judge that they still had a viable claim to start this lease? Maybe. So how do you cut that all off? How did you send the lease to them? Did you drop it off? Did you email it to them? If you emailed it to them and you can prove that you sent it by email, then you can also call it off. You can rescind the offer through email. And so if you sent it in one way and you rescind it in a like manner, that's usually very acceptable to a court. You sent it on, June 1st, hoping they would sign it on June 1st. They did not. It's now June 11th. You can send them an email and say, I hereby withdraw the offer to lease the property. I'm going to go with another applicant. It appears you are not interested, and so I'm withdrawing the offer to lease the property. I'm going to list it again and lease it to another party. Thank you. And so that's one thing. If you signed it, however, and you sent them a signed copy, and I see landlords do this, and I don't know why landlords do this. I hope you haven't done this. But if you sent a copy that you already signed, you kind of leave it open-ended for them to just add their signature and claim they signed it a long time ago. So I hope that's not the case. But if it remains unsigned, and specifically if they've already blown past the initial date and haven't paid you any money, then yeah, it's as simple as getting them notice of your rescission of that lease in the same way that you sent the original lease. If you emailed it to them, send them another email. If you put it in their hands, deliver in their hands another notice saying, I hereby rescind that offer to lease. Right? They would have to prove that they signed the lease and that you guys entered into a modified agreement, and they won't be able to do that. So I hope that helps. Question 7, Kim Collins Cross asks, is it 30 days from move out or 30 days from the day they send their forwarding address to return their deposit? Common question. Joy, you're welcome. Common question, Kim. It's both. So if someone vacates your property, but they forget to give you a forwarding address for 6 months, well, the clock starts ticking once you get that forwarding address. So from 6 months after, 30 days, you can send the deposit and or the itemized list of deductions, and then a deposit balance, if any, or a zero balance and a notice of how all deductions were made from this security deposit. So both are required before the clock starts ticking. Surrender of the premises and a forwarding address in writing to you. Hope that helps. Chuck Pace asks, and this is the last question. I appreciate all of you who commented and asked questions throughout this live. We're going to wrap it up here with Chuck's question. Here it is, the last one. Can a landlord who does repair work themselves charge the tenant labor? If this answer is no, what if the property is owned by an LLC and managed by another entity, both being managed by the same person? Well, you've got multiple legal issues going on here. I'm going to address your second one first, then your initial question. Number one, the entity, the LLC, is a separate person from the member of the LLC. So I have a PLLC. My law firm is run by the Law Office of Ernie Garcia, PLLC. But I and my law office are not the same individual. In the eyes of the law, we are two separate entities. I, the individual, and my company. So can my company hire me to do stuff? Yes, it can. And then ultimately, can I charge that to other individuals? Yes, that's the way my business works. And so can property be owned by one entity, managed by another entity, and can either one of these hire a third party to do work for them? Absolutely, perfectly legal, nothing wrong with that setup. Happens all the time. But your initial question was, can you charge tenant for that labor? I don't know. It's going to depend on a lot more facts than we have here, including whether you're repairing something that was damaged by the tenant or not. If it wasn't damaged by the tenant, then absolutely you can't charge the tenant for a repair you do yourself or that you hire someone else to do. So let's say it was damaged by the tenant. Well, unfortunately, if it was damaged by the tenant through ordinary wear and tear or through normal use, you still can't charge the tenant for it because you're not allowed to charge them for repairs that result from normal wear and tear or ordinary use. Let's say, though, you're doing a repair that is caused by the tenant through their negligence or their misuse. At all times, yes, you can charge for your repair. However, what is a reasonable cost for your repair? Well, if you yourself are not a professional roofer or a professional landscaper or a professional drywall person, how do you determine whether your time is reasonable? You may be an engineer and say, well, for my services, I normally charge $175 an hour. So I got to do some drywall work. I could be doing my professional stuff, but I'm stuck here doing this. I'm going to charge you $175 an hour for this work. Is that reasonable? Probably not. So how can you establish, even you as the engineer, how can you establish what would be reasonable for your time and effort? Is it in the lease? I strongly encourage landlords to put stuff like this in their lease. If I got to go and I got to go do this work, you agree in our lease to pay me $35 an hour for the work I got to do that you were obligated to do. Bada bing, bada boom, you've established a reasonable fee for your labor. Otherwise, you kind of leave it in the ether for a court to determine, right? Because it's not enough that you feel like that's reasonable. That's a fact issue for you to prove to a court. But if it's in the lease, very easy to prove, very easy to substantiate. So in a nutshell, if you're going to be doing some of your own work, make sure the lease reflects that. Make sure you've indicated a fair wage for your hourly work, right? Simple, simple, simple. A lot of people do this. All right. Idle Benz. Alberno says, good afternoon. Good afternoon. Alexander says, you mentioned a staff introduction a few shows back. Perhaps that could be scheduled after your vacation. Maybe so. Maybe so. Not a bad thing. I'll definitely consider it. Now, whether they want to show their faces in my lives is a different story. But I do want to thank all of you guys for showing up. I appreciate all of you who stuck around through the end. For any of you who missed the beginning, there will be a replay. You'll be able to watch it later. I want to thank all of you very much. I look forward to having a great vacation, in case any of you are wondering. James, thanks for wishing me a good vacation. I'll be back again next week, week after. No, but I will be back in 3 weeks. That's going to be July 2nd, right before 4th of July. I will be back and we'll have another live. And I probably won't have another break for the rest of the summer, barring any trials. But I do want to thank all of you for joining. You're welcome, Lucy. You're welcome, Brian. You're welcome, Alexander. I want to thank all the rest of you guys who joined. Hope you have a wonderful next few weeks. And as always, happy leasing.